All right, I'm going to call us to order because that's the time. Welcome to this event on the legacy of Justice Scalia. We got a great panel. Professor Lemos is going to do the introductions of our panelists, but I do want to thank the Program in Public Law and the Federalist Society for sponsoring this event and for the law school for its support as well. I understand that some of you might have to leave for a class at 1, perhaps. If you're one else, that's fine. If you do, just try to make it quiet. So,
thanks, Daryl. Thanks all of you for being here today. We are really lucky to have this opportunity to reflect a bit on Justice Scalia's life and the legacy that he's leaving us. Daryl said I'm going to do introductions. That's not actually true for the most part. You all know Professors Neil Siegel and Ernie Young. I do want to introduce our guest of honor who is coming to us. His name is Willie Jay. He's a partner at Goodwin Procter. He co-chairs their appellate practice. Willie clerked for Justice Scalia in 2004 and went on from there to spend several years in the Solicitor General's office doing appellate litigation before the Supreme Court, and then moved into private practice where he has continued his focus on litigation, I think particularly appellate litigation. And so he's intimately familiar with Justice Scalia from both sides of the bench. And so I think we should start with you, Willie, and feel free to talk about whatever you'd like for however long you'd like, and then Professors Young and Siegel will speak, and then we'll turn it over to questions from all of you.
Well, thank you. Thank you all for having me. Thank you all for being here, and I'd like to thank the law school and my distinguished co-panelists, and of course Professor Miller, who I've known since we were 1Ls together. So it's a real pleasure to be here to reflect on someone who was not just a great figure in the law and in kind of my professional life, but someone who was a significant figure just in my life as a person. So Justice Scalia. I think lots and lots of people have written and probably are going to talk this very morning about his, or afternoon, about his impact on legal writing and on judicial philosophy. So I'll say a little bit about that, but I'm going to talk a little bit more about what he was like to work for, what he was like as a colleague, and a little bit about what he was like on the bench. I think everyone probably has seen some of the classic Scalia-isms in your case books, and maybe even pulling opinions off of the Supreme Court's website yourselves. And maybe some of you have done what I used to do, which is look and see who wrote opinions, and then see that there's a Scalia dissent, and skip right past the majority opinion and head straight for the Scalia dissent, just partly to find out what the case was really about, what were they really joining issue on, but also partly for the cut and thrust, for the precious turns of phrase, to see what he had said this time. And I have to say, I was sad this morning to open this morning's two opinions and realize that there would be no Scalia opinion. In fact, there's not even an asterisk anymore saying, Justice Scalia heard argument but did not join the opinion. So how did all of that get there? And the answer from the clerk's perspective is through painstaking hours and hours and hours of polishing, reflection, and sort of annealing in the fiery furnace of Justice Scalia's determination to get everything just exactly right. Analogy after analogy would be tried out and discarded. He would come into the clerk's office and say, "What about this? What if we analogize it to a rapacious pack of dogs?" And someone would say, "Well, Justice, I don't think that works because, after all, the bait gets dragged in front of the dogs." And oh, good point. He'd shuffle out and come back half an hour later. Like, "What about birds of prey?" "I think I've really got it this time." And he would read the analogy. But so once he had finished revising a law clerk's draft, you'd get it back and you'd run a red line, and I distinctly remember the draft that I got back, that the red began at the top, and it went through page after page after page after page, where he had just cut everything I'd written. And there in its place was about one paragraph of basically perfection. Then he continued to revise that perfection a little more. And the revision process, once he'd gotten to something that was pretty good, you'd sit on the sofa with him. You'd have a cart full of books consisting of every source you were citing, every statute, every case in the original reporters, including the ancient English cases, every law review article, and he'd sit there and you'd get page 1. Right? This case, we turn first to our foundational decision in X. He'd crack it open, he'd read through it, and he'd have a red pencil, and literally would be red penciling the opinion on sort of triple-spaced tabloids as you go. And some of the best insights, some of the best little microscopic word choices he'd think of there in that last editing process before it goes out, before it went out, as he called it, booked the opinion. And that takes me into a memory that I have that my co-clerk has written a piece about. Maybe if any of you have seen it, then you can turn to your burritos while I tell the story. But so Justice Scalia was actually out in the courtyard booking an opinion one day because the power had gone out. And there was no electric light in his chambers, and so he went out in the hallway with my co-clerk and the cart full of books, and he's there editing away. And I tell this story because it's sort of a funny, it shines a funny little light on his interaction with his colleagues. So it was a weekend, so when Justice Souter came by, Justice Souter wasn't wearing a three-piece suit, he was only wearing a blazer and tie. Justice Souter's like,
Going to the beach?
exactly. So, I've just noticed the power's out. I've been working in there all morning. Justice Scalia said, what? He said, oh yeah, I always work in natural light. Justice Scalia said, that's probably why your opinions are so murky. And Justice Souter laughed and said, a light shineth in the darkness, and the darkness knew it not. And they both laughed and they went about their business. His colleagues loved him, even though he drove them crazy, as Justice Ginsburg liked to say. I think that was nowhere more true than an argument where he, as Dahlia Lithwick, who writes for Slate, accused him of hogging the ball. And I, as someone who argued there from time to time, I dissent from that. And here's why. I think Justice Scalia's argument liked to cut through a lot of the things that lawyers would rather talk about. He liked to take you straight to the text. He liked to cut through a lot of the sort of purposive and policy arguments that his colleagues would often like to ask about at oral argument, because, when else are you going to find out? Just how many people is this really going to affect? Or, does this really work in practice? What does the agency really think about this? How many times have you done this? Well, let's look at the text. But the great thing about Justice Scalia at oral argument is that although he would badger, he was persuadable, because he would listen to the answers, and many is the time that I heard he'd sort of pop up in his chair and say, which of our cases actually says that? And if you said Smith versus Jones, he would say, oh, well, that doesn't sound right. Did I dissent in that case? Yes, you did. Oh, okay. Even in the cases where he didn't know he was going to disagree with you, he was a persuadable voice at oral argument, and refreshingly, his questions got at what he wanted to get at. You could understand what he was asking. He told you what was on his mind. Sometimes you wouldn't persuade him, and indeed, one of the things that we rehearsed in moot courts was, if you're the government, sometimes Justice Scalia will be extending you what seems like a lifeline. Don't grab it. He'll want you to say, well, we shouldn't be reviewing any of these convictions, should we? Or, something, a more bright line, a more robust, more rigorous position, but one that the government just, couldn't endorse. But he told you what he thought. You might not agree with it, but he listened to the answers. He was persuadable. And if he wasn't persuaded, sometimes he'd just tell a joke, and that's why he continued until his death to win the laughter rankings, measuring the instances of courtroom humor in the Supreme Court, something advocates don't actually get to do, but you can sometimes be a foil for the justices. Justice Breyer said, I think, recently that the place is going to be a grayer place without him. I think that's true in print. It's going to be true in the courtroom, and it's certainly going to be true for his former law clerks. So with that, I'll wrap up.
Well, I want to thank my colleagues for organizing this and thank Willie for coming. It's appropriate that we do this. We have lost a great jurist, whether you agreed with him or not. I should warn you that the one time I ever spoke in front of Justice Scalia was at a conference at Notre Dame, and it was one of those conferences on a Friday afternoon, and naturally they'd put the speakers in alphabetical order again, and so I'm the last one on the sleepy Friday afternoon, and I should tell you, I actually did put the man to sleep. He was out cold from about midway through my talk, so hopefully I will not have that effect on you. I want to tell just a couple of Justice Scalia stories and then talk a little bit about his impact as a justice. So there is a custom that the clerks in each chambers have lunch with each of the other justices. And so we were slated to have lunch with Justice Scalia one day, and we were a little nervous about it because he's kind of an intimidating guy. And so we called up the Scalia clerks and we said, well, what should we talk to your boss about? And they said, oh, just get him started on something. Just argue with him. That's what he wants. So we go out to this place, which I think is the place that he took everyone, called Ristorante AV, which was in a kind of sketchy neighborhood of Washington, a very old Italian place. You go up to the maitre d', and the woman, says, ah, Nino, and she kisses him both cheeks and takes us to this back room. It's dimly lit. There's this large, intimidating Italian man pouring red wine all around. Ave Maria is coming over the loudspeakers. And it was like a scene out of The Godfather. But then, on the advice of the Scalia clerks, my co-clerk and your sometime professor, Stuart Benjamin, says, so, Justice Scalia, what do you think about gays in the military? And it was exactly the right thing to do. And we were off to the races for the rest of the time. It was a great discussion. Everybody had fun. Nobody got hurt. And I loved that quality about him. He just wanted a good debate, just wanted to talk about something interesting. And if people disagreed, that just made it better. Right? And that's something we don't see near enough of. The other story is a little more serious story. When I was at the University of Texas, he came down to give a talk, I think, to the Federalist Society, but he also did a talk for the Catholic Students Association that I sat in on. And it was about being a Christian in law school, or really, more generally than that, being a religious person in law school. And religious people were one of the few groups that it's still okay to make fun of, that it's still okay to stereotype in law schools. And he was speaking to this group of people, and he said, look, the Bible says we should be fools for Christ, and we are going to be considered to be fools, and that is okay. You are believing in something fundamentally irrational in a highly rationalistic environment, and that's all right. And you should, be confident and, be secure, and don't worry about that. It goes with the territory, and you're doing the right thing. And I just thought it was so generous and so necessary for people to be told that. And I think that was a side of him that people didn't often see. Let me talk a little bit about how Justice Scalia moved the needle in the law. And sometimes he did this almost single-handedly. So one of the most famous areas was legislative history. Justice Scalia hated legislative history, as I'm sure you know. And there were periods on the court where he was really, I think, the only one who cared about whether the court relied on legislative history or not. And so there would be all these opinions where he would agree with the result, but he would dissent from paragraph 3 on page 496, because that was the paragraph where the majority opinion talked about legislative history. And it just got to be such a pain to deal with the Scalia dissent, if you even dared to cite this stuff, that people cited it less. Other justices cited it less, even though they didn't necessarily share his convictions. I think they were also persuaded to some degree about the weaknesses of legislative history. And just the debate started an academic revolution of caring about statutory construction and statutory interpretation. We usually used to not teach that all that often. People didn't take that course very often. And now it's a major field of academic endeavor. I think originalism and using history much the same way. I think Justice Scalia made it respectable. It was impossible to ignore him or write him off as a kook. And so people had to grapple with these arguments, and that has also echoed in the academy, where we're now at a point where we're all originalists now. Jack Balkin is writing books called Living Originalism, and everybody accepts that this history is relevant. It's not the only thing. It's not always dispositive, but it's always going to be relevant. And so I think he really did make a difference in terms of how we think about the law. He was intemperate. And I think that in considering his legacy, it is worth criticizing him on occasion for, I think, crossing over the line in how he wrote about his colleagues and their arguments, and I think that detracted from his legacy a little bit. But it was part and parcel, I think, of what made him such a lively character as well, and so I don't, it's I think worth criticizing. At the same time, and I think it led to a larger problem, which was that Justice Scalia was supposed to be the William Brennan of the right wing of the court. He was supposed to be able to argue, to organize 5 justice majorities and really move the law in important ways of substance. And I think he basically failed to do that in most of the areas where he most wanted to do that. And I think it's linked to the problem of intemperance. As my friend Adrian Vermeule, who was a Justice Scalia clerk, once said, you can only call Justice O'Connor a nihilist so many times before she stops listening to you, right, and in print. And I think maybe someone with a little lighter touch might have been able to put together coalitions more readily. But I think that's just not who he was. I mean, he flourished in dissent. He flourished in really rigorous kind of lone argument, and we have to appreciate him, I think, for what he does. People don't like to be pushed anymore. People don't like vigorous disagreement. It makes them uncomfortable, and I think Justice Scalia always made everyone around him better by pushing them to be better. As a Souter clerk, we valued him, we respected him, and we thought he was often our arch antagonist, but we loved him for that, and everyone was very clear that he made our work infinitely better just by being there.
Well, thank you. Thank you to you both. And in my capacity as co-director of the program in public law, I want to begin by saying how pleased I am to be co-hosting this event with the Federal Society, and I'm grateful to all of you for being here, and especially to you, Willie, because you may be probably the busiest among us and also had the furthest to travel. And so thank you for honoring your justice's legacy in this way. Justice Scalia was a polarizing figure. I think everyone would agree about that. Some admired him, others revered him, some criticized him, others did more than criticize him, used stronger language. Let me start by saying what I don't want to do today, and then I'll tell you what I want to do. What I don't want to do is put myself on that spectrum and tell you what I thought of Justice Scalia, all things considered. I think what I want to do on this day, what I think is most appropriate to do to mark this occasion, is to identify for you those personal and professional qualities about him that I most admired. He's someone I knew, he's someone I liked, and he's someone that I miss. And there's a part of me that cannot believe that I'm talking about him in the past tense. He is the justice I spend the most time wrestling with in my first year constitutional law class, and I can't believe I'm doing it this semester in the past tense. First and foremost, about his person, he was a good friend to Duke Law School. He came more than once for various events, for a public interview. He taught in our Geneva program. I was his assistant in a separation of powers class he taught a few years ago, which meant that I answered whatever questions he had, debated him when he wanted me to, and then most importantly, wrote and graded the exams. But he was a good friend to many individuals and many institutions. There's talk now about how much traveling he did, and is there concern about bias? These justices have very limited time and a huge amount of capacity to confer legitimacy, relevance, and he was very generous with his time. I know many people who love humanity and don't love particular people all that much. He spent a lot of time helping other people out just by showing up. And I really admire him for that, and this law school benefited from it. He was a funny guy. I mean, it's not, he had his wit, his humor. He reminds me in a lot of ways of Marty Ginsburg, Justice Ginsburg's late husband, and I think it's not a coincidence that she was attracted, right, to both of their personalities, the kind of extroversion that really, I think, put her at ease and made her laugh. He had a real capacity for friendship along ideological divides, and I think it speaks very well of him and my Justice Ginsburg. I'm not sure what it says about most of the rest of us. He did not take some very profound disagreements personally. As Justice Ginsburg said when he passed, he was my best buddy from the D.C. Circuit, and that love they had for one another was quite mutual. He was a patriot. He loved his country and he loved the court, and I think that was quite clear year after year in what he did. Professionally, I agree with Ernie. He was uncommonly willing to engage, to debate. And so my favorite personal Justice Scalia story was on the last day of the separation of powers class in Geneva. I've told my students this, but I'll share it with the rest of you. He gave what a number of us like to call his originalism stump speech, right? You're either an originalist or you're making it up. Argle bargle applesauce, right? And at the end, dead. And at the end, he turned to the class and said, "Anyone want to disagree with me?" And then he looked at me and said, "Including law professors." And I think he was anticipating that I was going to explain why originalism was normatively attractive. And instead, what I learned over those 2 weeks, it had been a good term for him, and he was in a very good mood. This was the term before healthcare. And I realized I could criticize him in the form of a compliment. So I could say things like, "Oh, come on, Justice Scalia, you're way too sensible to be just an originalist. You yourself have said you're an originalist, you're not a nut." So instead of criticizing originalism, I identified way after way in which he's not an originalist, but also a structuralist, and also a doctrinalist, and also an historical practice person, and also a tradition person. And I said, then you've got to decide what you're going to be when, so you're also a prudentialist. And he just stopped and paused and said, well, maybe I need a new word for what I am. And I said, how about a judge? And then he laughed and he went back to giving his originalism stump speech. But that was an example of several ways. I asked him to, this would warm your heart, why do so many justices like you who purport to care about federalism find federal preemption so much? How exactly is there a standing in an affirmative action case when the person doesn't have a chance of getting in absent of, And he was really willing to listen. One time he said, I'll get back to you, when he thought about it for 24 hours. And then we talked about it. I mean, this was, he did this during class, he did it out of class. In the middle of a class, he didn't need to do this. He was doing us a favor by being there. He invited this, and I really admired him very much for it. I think what's said about his intellect, as well as his legal acumen, which are not the same thing, his analytical rigor, I think, were much more often than not quite true. I think he had an uncommon legal ability, and this would show up in the politically more obscure but legally important cases, in which he would often out-argue his colleagues on the court. Occasionally, you would see admissions against apparent ideological interest, as well as a willingness at times to change his mind, and I saw that in an important case the year I clerked. It was the year before you. I was there, OT 2003. And then one other quality I'll mention, which is that he was less willing than certain of his colleagues to say stuff that just wasn't true because the ends justify the means. And he was very willing to call his colleagues out for it. And so one of my students who's here today, Josh, recently asked me, what's my favorite Scalia opinion? And, I hadn't thought a lot about that, and I can't say that these are my answers, but they're not two you would probably think of, but I think they're great examples of him at his best. A lot of the qualities I just described, and they're both Fourth Amendment cases. And this is an area of law in which very arguably the court is now more conservative than it was when he was there. So the first case is Maryland against King. This was a case in which the police make an arrest supported by probable cause, and they bring someone to the station house, and the question is whether or not it's consistent with the Fourth Amendment for the authorities to take a DNA cheek swab and then check the DNA against the unsolved crimes database to try and match the defendant with some other crime that has been committed. And the court said this was consistent with the Fourth Amendment and they justified it as just a reasonable booking procedure, a way to try and simply identify who the defendant is. This is what Justice Kennedy said. The legitimate governmental interest served by the Maryland DNA Collection Act is one that is well established. The need for law enforcement officers in a safe and accurate way to process and identify the persons and possessions they must take into custody. This is what Justice Kennedy says for the court, and in dissent, Justice Scalia is having none of it. So to review, DNA testing does not even begin until after arraignment and bail decisions are already made, and presumably the defendant has been identified. The samples sit in storage for months and take weeks to test. When they are tested, they are checked against the unsolved crimes collection, rather than the convict and arrestee collection, which could be used to identify them. The statute forbids the court's purpose, identification, but prescribes as its purpose what our suspicionless search cases forbid, official investigation into a crime. Against all of that, it is safe to say that if the court's identification theory is not wrong, there is no such thing as error. Now, if you're actually grading the majority opinion and the dissent, I mean, you stop the fight, right? I mean, if this was Little League, then you would apply the mercy rule. There's just no argument here. Now, you can say it's being used to solve unsolved crimes, and that's nonetheless consistent with the Fourth Amendment for certain reasons. But to say that it's not being used for what it's being used as, and instead say it's being used for what it's not being used as, was just too much for him to bear, even if on balance he would like the police to be able to solve more crimes. One last example, this is Navarrete against California. This was a case in which the police received a call, a 911 call, and the person who called said, "This truck drove me off the road." And then a police officer shows up and follows the truck for 5 minutes and sees nothing amiss, nonetheless stops the truck, smells the pot, and then you've got yourself a suppression motion. That this was a Fourth Amendment violation. And the majority says there was reasonable suspicion for a stop, and this is what Justice Thomas says for the court. And listen to these reasons about why the 911 call bore sufficient indicia of reliability. By reporting that she had been run off the road by a specific truck, the caller necessarily claimed an eyewitness basis of knowledge. Yeah, so. Moreover, the short time between the reported incident and the 911 call suggests that the call had little time to fabricate the report. Really? How long does it take for a Carolina fan to see a Duke sticker on a car in Chapel Hill and call the police? Right? Finally, a reasonable officer could conclude that a false tipster would think twice before using the 911 system, which has several technological and regulatory features that could protect against making false reports with immunity. And Justice Scalia, once again, is having none of it. He says, the court's opinion serves up a freedom-destroying cocktail consisting of 2 parts patent falsity. That anonymous 911 reports of traffic violations are reliable so long as they correctly identify a car and its location, and that a single instance of careless or reckless driving necessarily supports a reasonable suspicion of drunkenness. So once again, he completely takes apart the majority opinion. The majority really wants to give the police this power because they think it's going to advance certain valid law enforcement objectives. But what Justice Scalia is saying, in a way that only he can, is that what you are saying is simply not true. And I need to be here to write this opinion to tell the rest of the world, if they read more than the majority opinion, that you don't get to make up your own facts here, right? And you don't get to make unreasonable inferences from those facts when you're crafting Fourth Amendment doctrine. So I will stop there, but with this person, there is much more that could be said.
Thank you, all of you. So, questions?
I was wondering if any of you could talk a bit more about kind of the state of originalism, textualism before, like in both in academia and on courts around the country, before Scalia's appointment to the Supreme Court.
I'm the oldest, so I can talk about the state of the literature in the 80s. In the law reviews, you would stop the fight, right? Because there had been so much scorn heaped upon originalism. Robert Bork had come out for it at his confirmation hearings, and that had really kind of put the issue at center stage. But for decades, there had been just article after article after article just lambasting originalism. It won't work, it shouldn't work, it would be bad if it did work, just hopeless. It just seemed like it had been completely refuted. And yet, And yet here you had, this incredibly articulate, brilliant justice, deciding cases this way and arguing for this theory, and it just made it impossible to ignore. And I think the other thing that happened was there had been an even greater problem with having conservatives in the academy prior to Justice Scalia, and I think I've never really explored why that would be, but my seat of the pants speculation would be that conservatism was not presented as an interesting intellectual theory of the law. Right? I remember citing an article once that said conservative constitutional theory should be interesting, but it isn't. Right? And it had been kind of inarticulate. Right? And Justice Scalia comes along and articulates a distinctively conservative theory of the law, and made it really, really interesting to people, and I think generated a group of conservative law clerks who wanted to go into teaching. And all of a sudden, there were two sides to the debate in the academy, and I think that helped immeasurably. And now you have people like Richard Fallon, and he wrote an article last year about the use of history in constitutional interpretation. He says, well, look, everybody agrees that originalism is always relevant to the story and often the whole story. And I just can't imagine a liberal law professor writing that in 1970 or 1980 or even 1990, and yet that's where we are. And Justice Scalia is, I think, more responsible for that than just about anybody else.
I can add a little bit on the textualism side for statutory interpretation. So the story is similar, and certainly the punchline is similar. So today, arguments about statutory interpretation begin with the text. If you don't begin with the text, you get yelled at. Even academics who are quite hostile to textualism will spend lots of time conceding the important sort of necessary features of textualism. The thing that's different, I think, about the textualism story and the originalism story is that, as Ernie mentioned earlier, statutory interpretation just wasn't a thing before Scalia made it a thing. It had been earlier, and then a large consensus had been built around sort of a purposivist, heavy on legislative history approach to statutory interpretation that by the time Scalia took the bench, and not the Supreme Court bench, but the D.C. Circuit bench, it just wasn't a topic of conversation among academics nearly to the extent it is now. And he made it interesting again by taking a really hard line against what had been the conventional wisdom, and really, I think, persuading so many people that there actually isn't that much to argue about anymore. So he might have created a field and then also kind of killed it. We'll see.
Could I throw in a couple of thoughts about that? So there was, I think, a famous, not that famous actually, speech by Ed Meese in the mid-'80s, right? Purporting to be it set out to be the definitive defense of originalism. No one reads it anymore, right? Ed Meese was not going to law schools and engaging with students the way Justice Scalia did for 30 years, and there's a real reason for that. Think of all the law school visits that were mentioned just in the first part of this panel. He did so much traveling precisely because he wanted to speak directly with the people who would be the legal profession one day, and he wanted his philosophy conveyed not through newspaper accounts of oral arguments or opinions. Scalia likes death penalty. Scalia, opposed to searching people. Whatever. He wanted people to understand that originalism was for him not just part of his deep and abiding love for the world of 1789 and a wish that we could go back to it, but instead it was part and parcel with his view of the role of a judge, that his legitimacy as a judge came from the fact that he was charged with applying the Constitution, and that the Constitution had the meaning given to it by the people that wrote it, and that to have the judges, based on their own perspectives from today, do a little updating of the Constitution based on what they thought right and just, was to undercut, was to eliminate their own legitimacy. And he would go out and say that much more articulately than I did, and explain why the dead Constitution, as he liked to call it, was not just, because he hated the results of the living Constitution. it was essential to being a judge purporting to apply the Constitution, to being a judge exercising the power to say what the law is and not what it ought to be. And on textualism, let's check back in 5 years and see what oral argument and briefing are like, and whether there's been backsliding. Because I think that Professor Lemos is exactly right, that if you don't begin a brief with the text these days, you do in fact get yelled at. But one of the people yelling at you would be Justice Scalia, and it will be fascinating to see what his successor, if any, and what the court without him think of those things. Because the one thing the justices say is that when one new person is appointed to the court, it's a different court. It changes the court deeply, not just because of who the majority is or the ideological breakdown, but just because of who they are. And the court that we knew well, ended a few weeks ago, and there's now an 8-justice court that will be different. And when his successor is confirmed, it will be different too. And one of the ways in which it really could be different is how rigorous an approach to textualism it takes.
I guess I have a bit of a different take. I think he's probably done more than any other single individual to lend legitimacy, respectability to at least one version of originalism and textualism. I think he's been more successful with respect to textualism than originalism in terms of what his colleagues actually do. So, I mean, there's really only one justice who tries to be a consistent originalist, much more so than Justice Scalia, and that's Justice Thomas, and he's the most likely to be sort of off on his own with writing opinions that no one else will join. Chief Justice Roberts and Justice Alito have both said they're not originalists, and Justice Alito gets into fights with Justice Scalia in which he makes fun of him, that we're going to really do this, with the way we did it in 1789. We're going to have a constable in the back of the carriage. It's, how do we analogize to a GPS device attached to a car? Textualism, I think, but you do have cases in which both sides are making originalist arguments. That happens more frequently than it used to. But it's also, you have important areas of the law in which really no one's making originalist arguments. I mean, they tie their interpretations of the Equal Protection Clause to the original meaning of Brown. Brown has displaced the text of the Equal Protection Clause, let alone what was going on in 1868. I mean, and race is not alone. Campaign finance, commercial speech, a number of things in which. So, I mean, I think the court remains pluralist, and I think Justice Scalia himself, to his credit, was methodologically pluralist. Nonetheless, you get more in the way of originalist argument than you used to. Textualism, I think I'm surprised when I go back several decades and read a Brennan opinion in which it's like they're not even looking at the text. It's just, here's the obvious purpose of the statute. And I think you're much less likely to see that anymore. I think both sides agree that you're going to begin with the text. And I think that's very much his influence. You're more likely to cite dictionaries, for example, regardless of your ideology as a judge than you used to be. But having said that, I can think of several recent prominent Supreme Court opinions that I think are more fairly described as purposivist than textualist, even though the majority could have chosen to write a more textualist opinion if it had wanted to in favor of that result. And so, more textualist, but again, I think it's overstated to say we've just got a sort of thoroughgoing textualist court.
This is really for anybody, but it builds off something that Professor Young said earlier about Justice Scalia sort of failing to be the Justice Brennan of the right. And I wonder if anybody thinks that was a conscious decision at some point, that to do the kinds of Justice Brennan was great at counting to 5, but criticized by Scalia probably the most for the logic and the reading of his opinions. And I wonder if you think Justice Scalia just wasn't willing to do that, to be in the majority, and would rather be right and move the academy rather than move the law and get 4 other justices with him.
I can tell you that Justice Scalia would say, I'm not sure that this holds up in 100% of cases, but he would say that you could judge him not just by what he'd written, but by what he'd joined. That he wouldn't join an opinion if he didn't agree with it. He certainly wouldn't write an opinion, in a mushy way that he d't believe in order to attract a majority. He would, essentially say, well, then let Tony write separately if he won't, go this way. And I can think of a number of cases in which he He wrote for a plurality for exactly that reason. But if you don't believe in multi-factor balancing tests, compromising on a test that has only 3 factors, that's not advancing the ball, right? You advance the ball by saying, I stand here against multi-factor balancing tests, or, I stand here in favor of the original view of the original meaning of this clause, or, pick your battle. And I'm certain that you can come to counterexamples and find Scalia opinions that you could say, well, gee, this probably is not what he would have written if he were writing a solo opinion, if he were the only justice on the court. But at the same time, I think that unwillingness to compromise is that's sort of the alternative label you can put on it. A lack of collegiality. Sometimes that was true in terms of the temperature of the rhetoric. But there certainly are cases where they were polite to each other, but in which he was just as unbending, and his colleagues were just as unbending. They had different approaches, and he wasn't willing to meet them in the middle, because to meet in the middle was to give up the game.
I think that's just right. I mean, Justice Scalia's superpower was being rigorously principled, and that doesn't really lend itself to compromising and forming coalition. I mean, Justice Brennan was certainly capable of really brilliantly analytical opinions, but he was also willing to give up his favorite argument if that would get him that 5th vote. And that's just a different way of thinking about the law. And it's hard to, because we think about what it means to be a judge in terms of being rigorously principled. But we tend to think of judges as solo practitioners, right? And so, when you're on an extremely multi-member court, it's a different thing, right? And so I think, he was, if he was picked to be Justice Brennan, they picked the wrong guy. I think Chief Justice Roberts might be the right guy for that, but that's a different kind of temperament.
And I think, I don't know him nearly I didn't know him as well as others did, but my sense of him and just of judging more generally, it's, the way you framed it is, did he make a conscious choice, as if it's entirely a cognitive exercise? If you think about think about someone's personal constitution, their character, their frame, their makeup. I just think when he saw a bad argument, he couldn't help himself. I think he couldn't stand it, right? He was going to call it out. And I don't think it was a conscious decision that if I want to move the academy and therefore over the long run have to, I think it was just, that's just how he responded. Every summer in D.C., I do one of these sit-down talks with Justice Ginsburg about the term and law and life, and this had been a recent term in which Justice Scalia had asked the most questions at argument and had written the most opinions. And I joked about the hogging the ball. I said, Kent, tell your buddy Nino to calm down a little and give someone else a chance. And she just started laughing and said, he's irrepressible, right? And she said it with joy. That was just him. And I just think this is how he was built. This is how he was constituted as a jurist, as a person. And he was this is how he saw it, right? And this is the problems he saw and what his colleagues were doing. And he wasn't willing to sort of, nearly as often as some others, to sort of move to try and craft something that he didn't really like, but that could give him a majority.
Stare decisis being a possible exception to that.
That's right.
That he did not always feel the need to write, I thought that opinion was stupid when I dissented from it, and I'm not applying it anymore, ever. There were areas where he would do that and would say that this is a made-up rule. It's just a bunch of mushy words on a page. It can't be intelligently applied, and I'm not going to try. But those were the exceptions. Whereas Justice Thomas, there's an opinion that a statutory opinion the Supreme Court handed down in 1984, before Justice Thomas was even a judge, and to this day he will not apply it, even though it has resulted in splintered majorities in the court, because Justice Thomas says, well, this is an arbitration case in state court, and I don't believe the Federal Arbitration Act applies in state court, so I'm out. Justice Scalia, one of the contrasts that he drew between himself and Justice Thomas was that he was not willing to do that, to basically take every case as if it were on a blank slate.
Yeah.
There were interesting debates about this when Justice Kagan was nominated. You might remember some of them. So she came in with a real reputation for being a consensus builder, and her her advocates said, this is what the left needs. You know, the left really needs someone like Justice Brennan. We haven't had one for a long time. We need someone who can build consensus and count to five. And other folks, but also arguing from the left, but just arguing about what the best approach is if you want effective decisions, said, you know, that makes me really nervous because consensus building suggests compromise and it suggests not holding the line. And I don't think there's a right answer to that, but it's in thinking through sort of what was it that made Justice Scalia so influential in the broader legal world, but that also maybe weakened his effectiveness in some areas of law just on the Supreme Court. I think it's the same trait, right? His refusal to bend and to compromise and build consensus, I think, is part of why he's such a hero to so many people, but it also meant he lost some cases. If you're interested in this topic, I commend to you, he has a fun article on separate opinions in which he has a lot of criticism for, you know, unnecessary concurrences that don't do that much, but speaks really glowingly of dissents and says, you know, if it weren't for dissents, none of us could stand to do this job, because that's the only time you can really say what you want, because you're not really looking for people to join you. And I think that's why, in part, you know, many of us, when reading opinions, would flip to the Scalia dissent, because you know that's where you're going to get, you know, the straight talk. And I think some of his most powerful opinions have been dissents, because he was just writing for himself there and really could just, you know, do that fully and not have to compromise even a tiny bit.
And he liked to say that our worst opinions are unanimous ones, right? Because, you know, you just write it, you get, you know, 8 other justices to join it, and you send it out there without anybody saying, that's garbage.
Yeah. Other questions?
Do you think that while we have an 8-justice court, that any of the other justices will adjust in any way their behavior at oral argument or anything else to compensate for Justice Scalia's absence? I'm thinking like along the lines of Justice Thomas asking a question at oral argument yesterday.
I saw Justice Thomas ask a question once, and the guy from the guy from the Solicitor General's office didn't answer it, and I thought, man, he's never going to ask another one. There is this weird phenomenon that Kathleen Sullivan noted like 20 years ago, 25 years ago, that the justices on the court seem to think it's important on some level, whether it's conscious or unconscious, for like all the positions to be represented. And so sometimes they spread out, and you know, when the composition of the court changes. And so, for instance, I think I've noticed this in Justice Kennedy's behavior. Once Justice O'Connor left, he became more O'Connor-like. He was a pretty reliable conservative vote on a lot of things, including race, for a long time. And then once she left, and he says, holy cow, we can't have a court without Justice O'Connor, I guess I better be Justice O'Connor now. And so I think they do kind of think that there are certain functions and roles, and you may see somebody try to step into that a little more.
Justice Kagan at Justice Scalia's funeral actually said something about, you know, about that, you know, we all kind of have had our appointed roles at oral argument, you know, and that's going to have to change now. You know, somewhat, if they all just kind of continued on as they've always been doing, and there's no successor for a while, there's something they'll be missing.
You may have a process where several justices try to be the funny one,
Yeah.
with varying degrees of success.
Yeah, I hope not. Yeah, I also was at argument on a day in which Justice Thomas asked a question, and he has this unbelievable voice. It was like the voice of God descending from the heavens. And it was in Virginia against Black, a cross-burning case in which his intervention changed the whole tenor of the argument. So the idea that race doesn't matter, after he talked about what the social meaning of a burning cross is, through his own eyes, just the whole rest of the argument, read the transcript, listen to the audio, it changed. And there was much less willingness to contest, right, that view of the meaning of the event after he spoke. You know, it is striking that he spoke, right, and maybe that's going to change. Maybe he's going to speak more now. I think one of his concerns in the past about speaking is that the advocates have no time to get to talk, and Justice Scalia was often the most robust questioner. And so it's not like there's just 1/8 fewer questions now, right? It's more than that, 1/9, I mean, it's more than 1/9, right? And so he may feel like his talking more is still consistent with allowing the advocates to say what they want to say. So I don't know, but that's at least possible.
The government lawyer, actually, who he asked the questions of, was about to sit down. She had said, if the court has no further questions,
Right.
you know, and had time left on the clock.
Interesting. So that's a great, yeah, so that's right, I just read about that. And so that's a great example of he wants them to be able, the lawyers to be able to talk and make their points, and at that point, intervening was not inconsistent.
Although, in fairness to Justice Scalia, he was also one of the most reliable people who would do this. You would say, I'd like to make 3 points about that. And you start about you're halfway through the first point, and Justice Breyer asks a 3-minute hypothetical, and Justice Scalia, you know, you get your answer out to that. Just you had 3 points, right? I'd like to hear the other 2. And, you know, sometimes for an advocate, that really could be a lifeline.
I had a question about whether on the current docket or something that you might anticipate coming up in the next couple of years, what are like some of the big substantive areas of law that you think will be the most impacted by either being an 8-person court or just there being no Scalia on the court? I mean, where do you think we're going to see the biggest movements now that there's been this shift?
There's a lot that can be said. Are you saying while it remains an 8-person court, or?
I mean, just foreseeably while there's still an 8-person court, or just what's coming up that we're going to see the biggest kind of drastic shift without Scalia than we would if he was still on the bench?
Well, this term, I think the Public Employee Unions case, the First Amendment challenge there, it was looking more probable than not as a 5-4, right, to find a First Amendment violation. Now it seems more like a 4-4. The UT Austin affirmative action case, Kagan is recused, and so it's still a 7-justice court. They're probably going to be less inclined than they might have been to issue a broad ruling. I suspect the university is still going to end up losing the case. There's a significant abortion case being argued. I believe it's tomorrow. Is Whole Women's Health tomorrow?
That's tomorrow.
And that looked like, based upon the pre-argument behavior of the justices, that the Fifth Circuit seemed more likely than not to be reversed 5-4. Maybe now it'll be 5-3. Those are at least some that come to mind. The Texas immigration case now, I think, becomes, it's, you know, I think it's much less certain what's going to happen. You know, if you start talking about what happens years from now, I mean, you can let's just walk through all the enumerated powers in the Bill of Rights, and I can point out to you area of law after area of law in which you have, with some non-trivial exceptions, but a lot of previous 5-4 splits that are now going to be open potentially for reconsideration. But
Although not all the 5-4 that you're thinking, right? Some of those 5-4 splits are Justice Scalia, Justice Thomas, and 3 of the more liberal justices on criminal procedure.
right, those are the notable exceptions.
Right.
Yeah.
Right. No, but you replace Justice Scalia with a clone of Justice Sotomayor or Justice Breyer, and, you know, the confrontation clause starts to look a lot different.
Yeah,
Whether you-
sentencing, confrontation, Fourth Amendment, there are ways in which the court is going to become more, the way people tend to code it, ideologically conservative. Right. I think those are significant exceptions that get less media attention. I think that's right. But when you start talking about campaign finance and First Amendment challenges to public employee unions, and who knows what's going on with the Second Amendment, the court keeps refusing to grant cases. You talk about abortion cases, you talk about affirmative action cases, enumerated powers cases, right? Various federalism objections. What about sovereign immunity now? I don't, you know, to what extent is stare decisis actually going to make a difference here with a differently constituted court if there is a liberal majority that emerges, that I think is going to require more than just replacing Justice Scalia, given the age of the other justices. I think it's going to be what happens in this next election or two, and what happens in the Senate. Then I think a lot of things are up for potential reconsideration. In the relatively short term, there are ways to manage an even number of justices, right? You can write narrowly and get a majority. You can set cases for re-argument. You can dismiss them as improvidently granted, or you could just split 4-4 and just leave the lower. You know, there are ways to manage it. It's just not. You know, my hope is that we're not going to be managing it a year and a half, 2 years from now, because there's a reason why the first court had an even number of justices, and after that, right, we thought that was no longer a good idea, right, and we had an odd number for the most part since that time.
We probably have time for one more question.
Scalia was notably critical of some of the lack of geographic diversity and intellectual diversity on the court in terms of, all of them coming from certain schools, all of them largely coming from the same areas. So I was wondering, aside from being an originalist, what are the sort of qualities do you think that Scalia would want to look for in terms of a replacement?
So I think that passage is often misread, and that his point was not, we as a court ought to have 3 farmers, 2 people who grew up in New York City, 2 people from Texas, and so on. His point was, why would you assign the job of resolving our most deep and serious disputes as a democracy to an unrepresentative group of 9 lawyers? Right? That not that they ought to be more representative and keep deciding all the same things, but that they, he didn't care how representative they were. They ought to be deciding fewer things as constitutional matters. So I think, I think that David Axelrod had a piece about Justice Scalia saying to him, look, I know your guy, the president, is not going to appoint someone who would agree with me. Send us, I hope he sends us someone smart. And I think that's what he would want his replacement to be.
I would say someone smart who's going to preserve his legacy. I think justices don't love the idea of replacements undoing what they've accomplished. And so I would think it would be a combination of intellect, acumen, horsepower, and someone who sees the law in a way that's similar to him.
I think we should have a lightning round with everybody's favorite Justice Scalia quote. I'll start.
Oh, okay.
You should just do 4.
Morrison versus Olson. The dissent in Morrison versus Olson, talking about the independent counsel law, he begins the dissent, he says, oftentimes threats to the constitutional separation of powers come before this court as a wolf in sheep's clothing. If the issue is not plainly presented, it seems like a small thing, I'm paraphrasing a little bit. But this wolf comes as a wolf.
I don't have full quotes, but I so appreciate the words, I mean, just think of the words we got from Scalia in the last, year or two. We got argle-bargle. We got applesauce as, not the thing you eat, but an argument that is, you need a spoon with. Those are just so wonderful. I can't even go back. I'm blinded by them. Do you guys have good ones?
So the Maryland versus King opinion that Professor Siegel read from, I believe the last line of it is the proud men who framed the Fourth Amendment would not have been so ready to open their mouths for royal inspection.
No. Yeah, I think the 2 I offered before are pretty good.
So let me ask one last question. This is along the lines of favorite Scalia quotes. So Willie, I've always been curious how the clerks perceive their role in terms of coming up with wonderful lines like this. Was it your goal in life as a clerk to get one of those in an opinion, or did you just leave it to the justice?
It's a good question. I do think that we tried to write an opinion as he would, because after all, unless we do that, we're worse than useless instead of, mostly useless. I really think that being a Scalia clerk was a daunting task, because you're kind of like a, left-handed pancake turner. You are somewhat useful, but the job could be done without you. He really could have done it all himself. He just found us sort of a labor saving, maybe a dishwasher is a better example. We were a labor saving convenience, but you're not helping him if you're not at least trying to write it as he would. I do think that from time to time people would kind of get out over their skis and write something a little too precious, and I can think of things that my co-clerks drafted that either it just sounded too good, but it doesn't actually stand up analytically. It's not a good analogy. Or, despite what everyone may think, he would say, we shouldn't say that. Too mean. Or he just preferred to say it differently. But I am certain that many of the Scalia lines that people like, some clerk had some role in drafting it and he liked it. Just as if if he fastened on something in a brief that was well said, he would fasten onto it and say that was good. Let's quote it. And he doesn't have to quote the law. Doesn't have to attribute anything to the law clerks.
Okay, thank you very much for being with us, Willie. And thanks,